Hi everyone. We've gathered here today to discuss a very nuanced and important topic in today's times, the law and the nuances around deepfakes, AI, and personality rights, how things have been spanning around in the legal circuits, how the courts are dealing with these situations, how the law is developing on this very aspect. Let's just start with a question. You have a celebrity who finds out that there's an advertisement which he has never endorsed, which he's never acted in, but he finds his own voice and face on that advertisement. You have your own office colleague who gets up in the morning and sees a WhatsApp video circulating where he or she finds himself mentioning something, playing out a song, dancing to a video, but she's obviously not done it herself. And the video today is transboundary, it's gone across the world. Where does one protect himself or herself in this sphere of digitization, in this sphere where AI is today taking over the world? So let's start discussing and where exactly is the starting point of all of this? Where does the law really help you in protecting yourself, say in terms of, let's first take up personality rights.
So, Malak, that's actually a very interesting conversation to start with, I feel. Personality rights, and there are a couple of aspects to this conversation. Personality rights are not just limited to a celebrity. You have your personality rights, I have my personality rights. Um, a vegetable vendor, he has his personality rights. And then we have Bollywood stars and other actors and actresses who have their personality rights. Today, unfortunately, each one of us as human beings are at the risk of our face or our personality rights, be it our mannerism or our voices, being copied or emulated, if I can say, to the benefit or to the use of whoever else may so want. AI is, of course, a very valuable tool that is helping in lots of ways in the progress of work arenas and in society generally, especially the way even lawyers function. But having said that, this risk is becoming more and more imminent. I was reading an article recently which said that Shah Rukh Khan was the Bollywood actor who had the maximum number of deepfake videos in 2025 alone. Does that create a sense of confusion? Does that make him stand for something that he's not saying? Does that lead to his fan base, which is trans-nation, trans-continent, assume and presume that, oh, maybe Shah Rukh did this stunt, or maybe Shah Rukh is supporting this candidate, or maybe Shah Rukh is supporting this product? Yes, it does. In such cases, and we've seen very actively, Delhi High Court has been passing John Doe orders where anybody and everybody is stopped from using my personality for creating any videos, photographs, any other social media content, because my rights are exclusive to me. Let's step back now. This is in the AI time. This is during the Gujarat riots, and I remember reading about this back in the day. Of course, this is no coincidence that you're from Gujarat. But during the Gujarat riots, there was a face of one gentleman who had lost his daughter. And that became the face of the riots because a photographer had taken his photograph and sort of published it and sold it to Getty Images and sold it XY to other platforms. And that raised an issue saying, did he have the right to do so? Because really the right stems from, I have the copyright to my own face. Nobody can take my photograph without my consent. So there's a copyright issue, there's a privacy law issue, and then there is, from that stems data protection.
In fact, that's a very interesting point that you raised, because when you talk about personality rights, effectively you're looking at a discussion around conflicting interests of a free speech or expression and one's personality rights, which stems from the fact that you have Article 21 rights. In fact, if you go to the law which was there since 1980s around freedom of expression and typically obscenity laws. If you look at the case of, say, Raj Gopal, you had a biography published of someone who was in custody and his trial was going on, and that became a very big issue as to whether someone else could have really, gone into my rights, my personal image and published things on it. Now,
Yeah.
so and since you raised Delhi High Court and personality rights, let's just go into that sphere. So you have the Supreme Court in a 9-judge bench decision in Puttaswamy
Swami
saying
Singh.
that you have
Privacy.
bodily autonomy. Like
Yeah.
every person, when you talk about a right to privacy, has a right to bodily autonomy.
Autonomy.
I have a right to deal with my body, my image, my face, my
Correct.
voice the way I want.
Correct.
Now, the moment I have a corresponding or a contradictory right belonging to someone in the domain of free speech, to what extent can that free speech be regulated or modulated so that it does not impinge upon the personality rights of someone else, while it may not be a creative expression, but just the fact that he is being, or the fact that he has, I mean, is alive and has a right of just living the life the way the life he wants to, can that really amount to what today we loosely term as personality right? Now let's take an example. You look at the latest judgment, that order that Delhi High Court passed in the case of Raj Shamani. So the court said that since he is he makes reels and he is basically a podcaster and he's known in the digital field with his voice, he also has a trademark in the name of the podcast that he runs. Therefore, people associate him to that particular podcast, or his voice is recognized to that particular field, and therefore
That's
the
personality.
correct, and which is why the court doesn't really go too much into the details of the law, but just says that his voice and his the way the mannerism of his speech is protected largely under the Copyright Act.
Correct.
What Let's take this example further, and you have, say, a director of a company who's today sitting on a WebEx board meeting. You may have a situation where his voice is copied, or a deepfake is created as if he's sitting in that board meeting
And saying something
and
else.
saying something or approving something which is not done by him.
Yeah.
Now, leaving aside the criminal aspect of it and how it will amount to
Forgery
violations,
or yeah.
etc., but just the fact that someone did this, is that a violation of personality right as such? Because that's exactly where the skirmish lies. You can protect a personality right to the extent of the specificity of your persona, of your face, for example. It's a unique thing, but the fact that there is a usage of your voice or the usage of your face by someone to express something, will that amount to a violation of a right which is embodied within any law? Today the problem lies that there is no specific law which addresses it.
Of course, I hear you.
And which is where your the discussion around, does the personality right belong only to someone who the public sees as someone who has a public figure, or is a celebrity, or does it belong to everyone, really starts.
So, I'll answer the last bit of your question first. We live in a country, fortunately, where there is equality before the law, Article 14. And then there is Article 19, which is, and then there is Article 21. All these three articles apply to every single citizen of this country, or in certain cases like Article 21, to even non-citizens equally. So you don't have to be Amitabh Bachchan to come to Delhi High Court to seek an injunction where your voice is protected. If today a common man who's a school teacher observes that some children have recorded his voice and then created a deepfake video using that voice to maybe disseminate certain an agenda or certain wrong teachings, or something that is not in alignment with him, or something which may even be alignment with him but is done without his knowledge and consent being absolutely important here, does that constitute a violation of his privacy? Does that constitute a violation of his copyright or his form of expression, therefore amounting to his personality rights being breached, making such act amenable to civil and criminal action? According to me, absolutely yes. Because that is data being taken from me, digitalized, so there is, you come under the Digital Data Protection Act, where you can't be used, you have to justify why you're collecting my data, what you're using it for, where you're storing it, who has access to it, and what recourse I have. These are the 5 foundational steps or foundational pillars on which any kind of data that is collected is to be used. So,
in fact, since you raised the DPDP Act, let's touch upon this a bit. In fact, that's very interesting because recently we have the rules which have been notified, and since you spoke about content, in fact, consent is one of the biggest aspect that the rules cover. That till the time there is express consent given for the purpose of usage of data which belongs to the person, and you call it sensitive personal data, that action of using it without express consent, be it implied or be it tacit, etc., will definitely fall foul of one's personality rights or one's digital protection. That in fact brings us to the next aspect, that once you have a framework now in place, and that's the framework that we largely now bring in through the rules, is the enforcement mechanism as to how this ultimately is going to work out. Now, if you look at the orders which have been passed, say by Bombay High Court or by Delhi High Court, they're typically all ex parte orders which are John Doe in nature.
John Does, really.
And John Does will, to an
John
effect,
Does also bring their own limitations of implementation, right?
correct. So the enforcement aspect definitely becomes a big problem, that till the time you have targeted a specific set of people within your petition, fine, they will be bound by it. But a typical John Doe is very difficult to enforce, because then you are called upon yourself to go and hunt as to where exactly a personality right or a violation is taking
I'm
place.
glad you're saying that, because see, and this is the way I look at it. Come up, give me your views on this, and which I think is very important for our viewers also. The advantage of, and this comes from a place where you see a gush of a lot of Bollywood stars coming to Delhi High Court to seek these orders. One, of course, is the question of jurisdiction. How come they're coming to Delhi? Because then that data is probably disseminated everywhere, and the law is very clear that you can come wherever the data is disseminated. Second, what is the advantage of sitting on a John Doe? Today, my understanding is, if there is an advantage of sitting on an omnibus John Doe like that, you may come today saying that there is this one deepfake video. But the minute your personality rights, which are beyond one video, are protected by an order, which is the John Doe order, which is against the all and sundry, protecting your rights, the next time there is such a video, you don't have to run to court. You can simply write to Google, you can write to Meta, you can write to Twitter, or whoever account that has been circulated from, whether it's on WhatsApp also, that look, there is this prohibitory order.
Correct, but see that,
so expedites your dissemination.
Correct. Now that in fact
expedites the containment of your dissemination.
And which is where on social platforms like Facebook or Meta or Google or WhatsApp, the problem really stems from the fact that today you may have a order which is applicable in the boundaries of our country, but these are apps which work jurisdictionally across borders. So will that order be applicable, or will that order work itself out? Because once your video is out there on the WhatsApp domain, it's out there across the world. I mean, I could have sent it to 10 people on 10 groups who were all sitting outside the country, and which is where the challenge really will come in as to how the DPDP rules really work themselves out, and how globally is this compliance going to be made, because effectively
I don't think that's going to be very easy. Frankly speaking, I think it's going to be a huge challenge.
It's never going to be easy to bring up something, because today there's a constant fight on
everything is real time
and keeping technology in the tight constraints of legalities. But it'll be very interesting to see if someone like you and me, who doesn't really fall in the category of a celebrity, reaching out to protect his personality.
I'm sorry, manifest it. We're celebrity lawyers. Please manifest it.
So we'll keep it at common lawyers for now, but it'll be interesting to see how this really works out on using, or for that matter, let's say not even a celebrity, but
a common man.
Let's take the best example of a judge. A judge who's sitting there on a boundary, on a public domain live streaming. Tomorrow someone can use his video and end up being...
No, but haven't we been seeing a lot of now these videos, and you're getting all these notifications from TRI that there are these videos that are being circulated where people are saying we're judges calling, we're calling from CBI to try and extract money from people. Tomorrow they can use maybe the Chief Justice of India's or some
digital arrest scam.
Digital arrest. So where is all of that going to lead you? At some point there will have to be specialized courts for enforcement of this. Maybe collectively the WTO will have to work to, or some international collective will have to work to create a repository or a court for seeking enforcement of orders or providing protective orders.
Correct. So all in all, we are looking at some globalized mechanism coming in, and let's probably stop here and probably deep dive into this a bit further. We'll try and cover this more. And thank you so much for having us. In fact, since we were on the question of consent, if you look at typically how a lot of these brands or OTT platforms have worked in the past, and I don't know if many of you have used it, there are specific apps where I can send you a customized video where a celebrity would be wishing a birthday wish to you or a anniversary wish to you, is where they take a license from that person, either on an exclusive or non-exclusive basis, saying that we are using your one line or one paragraph of the way in which you speak for the purpose of creating a commercial content on our calendar, on our platform. But de-horse that once you go into the domain of unregulated use of personality rights. That's where really the skirmish between free speech versus content creation versus the right of that person to protect his voice and face really comes in. So
I think, to just sum it up, Malak, I feel there's a lot that has to be done still. We're still at a very nascent stage when it comes to digital rights, personality rights. We need to, where the system needs to be educated. When I say system, you also need to start as young as children in schools.
Absolutely.
You need to, children need to be, like children today have access to phones in grade 5, grade 6. You don't know who's filming them. They need to be aware that you can stop someone and say, look, you can't take my photograph. But that's a right, they need to be explained and taught. Right up to prosecuting agencies, police, judges, us as lawyers. I think the mindset and the awareness around the rules, regulations, or the lack thereof, the means of best implementation will have to be tightened and then percolated down to the system for anybody going forward to feel safe in their own personality and that they own their personality without it being hindered or disturbed by anybody else.
So that is a standard law. Section 79 of the IT Act says as an intermediary, you are supposed to check if the content is right or not. So in fact, in terms of the DPDP rules, if you look at the mechanism, one of the mechanisms that can work out.
No, that's not the question. It's about the watermarking. But doesn't the DPDP rules say something on this? I think they do.
I'll put a generic answer that this is one of the mechanisms which is going to be worked out.
So, Malak, don't you think on a bare reading of the DPDP rules, somewhere they are stringent. They put a lot of checks and balances in play. One of the checks and balances that also should come in is that any AI content, there should be a disclaimer.
Correct. So in fact, most of the way the mechanism of the rules seems to be placed is that there is going to be a mandate on the AI platform itself to disseminate information only with a background to show that the video is generated by the use of an LLM or an AI. And that's obviously one way of it. The other stems from the general law which anyway exists under the Information Technology Act and the rules, is that intermediaries by themselves have grave duties upon themselves to ensure that fake or any negative any content which is against the Indian law cannot be disseminated on their platforms. But that obviously will now have to be amplified to ensure that AI videos
in sync with the DPDP
and that any videos which are generated through AI platforms, especially using someone else's personality or voice, should contain that disclaimer.
Their consent and
either of the fact that there is a consent given by them or the fact that it's a generated video which does not have themselves speaking on it.
Yeah.